Welcome to Legal Aspects of Concurrent Planning. This is part of the Legal Aspects DVD series. My name is Jeannie Gordon, and I'm the Legal Issues Training Coordinator for the Children's Division. The date today this is being recorded is May 17th, 2010. I want to call your attention to the materials that accompany this DVD. You can find them on the Children's Division intranet. If you go to Professional Development and Training, look for the Legal Aspects DVD series. Follow the links to the Legal Aspects of Concurrent Planning. You'll be able to download a copy of the PowerPoint and the list of TPR grounds which accompany this training. The presentation today is on the legal aspects of concurrent planning, like I said, but they affect family engagement, they affect FST decision making, and they affect achieving permanency in a timely manner. So let's take a look at the topics we're going to cover. How the due process rights of the parents apply from removal to achieving permanency. We're also going to talk about the legal requirements and limitations on concurrent plans of guardianship and adoption. Just want to make sure you know we're not going to address all the plans. We're just going to address the two that are legally permanent. We're also going to take a look at the 8 TPR grounds and what that means and why we need to know about them. And lastly, we're going to look at concurrent planning as expedited permanency for the child. Let me ask you this. Have you ever had any of these problems in your cases? The permanency plan's been changed to adoption at the permanency hearing. They get the TPR petition filed. Dad shows up at the TPR hearing, says he didn't know he was the father, but he wanted paternity testing, and if he's the dad, then he wants custody. What about when the FST recommends the plan change to adoption at the permanency hearing, and the court decides to continue efforts to reunification, and you don't understand why? Have you ever had any cases where the child clearly needs permanency because one parent is dead and the other parent is incarcerated and will be until the child's over 18, but the TPR is overturned by the Court of Appeals? What went wrong? Lastly, what about the permanency plan changes to guardianship when the child has been in care for 6 months because both parents are willing to consent to guardianship to an out-of-state relative who's willing to be the guardian? But fast forward 6 months, the ICPC process is so slow and that child has yet to be placed there. Where's the problem? In the process of talking about all the legal implications of concurrent planning and all the sources of the law that apply to these cases, hopefully we'll be addressing these type of issues for you. So we've talked about the topics, topics to be covered. And now we're going to move on to the legal fundamentals. There are sources of the law and for Children's Division policy that underlie all the work that's done in child welfare cases. And we kind of need to understand all of this because I think it really affects a lot of what happens in the cases and what goes wrong. So to begin with, the division's authority to act under the law comes from the Constitution, both federal and state, from federal and state statutes, from the Supreme Court rules of procedure, and agency policy. So when I'm talking about the Constitution, you know, kind of what am I talking about? Well, parents have what's called a liberty interest in their children, in their relationship between the parent-child, and the child has that same protected liberty interest in their relationship with the parent. And state government cannot interfere with that relationship without first providing due process of law. So that's one of the big constitutional issues we're going to talk about. We're talking about the 4th and 14th Amendment are the ones mostly that are applying in our cases. We're also going to talk about federal and state statutes. If you think about it, 10, 12 years ago, the Adoption and Safe Families Act was implemented in about 1998, and that expedited permanency for kids. And I don't know about you guys, but I did an awful lot of TPRs in South Central Missouri during that period of time. There are also state statutes that affect the Children's Division's ability to act. Section 210-145 is a statute that is the hotline scheme, which includes structured decision-making. There's a whole series of statutes that go to that. There are statutes that address having FST meetings before placement changes on a child. So there are various statutes that apply to the work we do. Thirdly, there's the Supreme Court Rules of Procedure. The easiest explanation for that is the juvenile officer is going to file a petition in juvenile court, and that's a substantive right that the statutes provide for. But how do you get that case through court? That's part of the Supreme Court Rules of Procedure. They're procedural rules that say this is what it takes to get these cases through court, how they're heard, when they're heard, how you change judges, how you notice up a hearing. All this various information is provided in the Supreme Court Rules of Procedure. The Supreme Court Rules of Procedure also changed, just as an aside, January 1st, 2010, and they make it perfectly clear in the definition of parties to the case that the Children's Division is a party to the case, whether they are the custodian of the child or whether the child and the family are under their supervision. Agencies' regulations also come federal and state regulations. An example of a state regulation would be when you think of termination of parental rights, there's lots of money that gets paid to the guardian ad litems and the attorneys for the parents in those particular cases. Well, there's actually an agency regulation that says how much a guardian ad litem is entitled to in a contested TPR and how much the parent's attorney are entitled to in a contested TPR. And oh, by the way, the statute also says if the court makes the finding that these are very complex cases, then the attorneys can actually be paid more money. So that's an example of an agency regulation. Lastly, there's agency policy, and Children's Division policy fills in a lot of blanks on the social work side and is also contains a lot of policy that implements state and federal laws that have been written that apply to the Children's Division. So the constitutional law that we are starting off with, that is the supreme law of the land. And any of the rights that are given to individuals, to us as individuals, and to our families, i.e. our parents, those are rights that cannot be taken away from them. So we always have to remember that these constitutional rights are pretty important. They're protected. They're fundamental rights protected by the Constitution. And the state is always going to have to meet its burden of proof and provide due process anytime the state is going to try to interfere in the parent-child relationship. Okay. This is a reminder that the bond between a parent and child is a fundamental societal relationship and one of the oldest that's protected under the Constitution. The particular case that's cited at the very bottom of this particular slide is in the interest of KAW, and that is a Missouri Supreme Court case on TPR that talks about this fundamental relationship between the parent and child and what it takes in order for a TPR to permanently trump someone's parental rights so the child can move on to a permanency plan of adoption. Don't forget that parents' rights just don't disappear. Just because they've been bad parents or haven't been model parents or lost custody of their children, they still have these constitutional rights. So in most cases, parents are entitled to get their children back or to attempt to try to get their children back, with a few exceptions where no reasonable efforts are required when the court makes that type of finding. What you've got here is we're talking about these parents' rights and that the child has a right to a relationship with the parent and that the state can't interfere without providing due process. But these rights are not absolute. The parents do not have a right to abuse a child, to be free from a reasonable child abuse and neglect investigation, and their rights have to be balanced against the state interest. So the state has what's called a compelling interest in protecting children from abuse or neglect. So what is this compelling interest? Well, it's the authority to investigate, to protect kids at risk from being abused and neglected, and to provide protection and treatment to kids who have been abused from future abuse. these are very similar. This particular slide is very similar to Section 210.145, which talks about, that gives the division the authority to investigate child abuse and neglect and to protect children, to provide services to prevent or reunify consistent with federal and state law, to maintain the hotline, and to provide due process to the perpetrator. So again, now we've talked about parents' rights and we've talked about the state's interest, but the state's interest is not absolute either. We can't just ride in on that white horse, scoop the child up, and ride off into the sunset and live happily ever after. The laws are not designed that way. The state's rights to protect kids are not absolute. They have to be balanced with the rights of the parent. They have to be balanced with the rights of the child. And they have to be based on authority granted by law, which is mostly our Missouri state laws and some federal laws. And there must be a reasonable factual basis. Okay, so parents, because of their liberty interest in their children, that's the L word under the Constitution, are entitled to due process of law under the 4th and 14th Amendment. So the idea behind procedural due process is the government must act fairly and provide fair procedures to people before the government can take an action which impacts their rights. So what is due process? Well, it's reasonable notice and opportunity for hearing at a reasonable time and in a reasonable manner. The person is entitled to reasonable notice of the basis for the action against them and an opportunity to tell their side of the story. And for most of our purposes, it's going to be in court or at a CAIN hearing is what we're talking about. So the general rule is that the Constitution requires the government to take notice and to give notice and have a hearing before someone's rights are impacted. There is an exception, though, in child welfare where we don't have to provide that due process first, and that's called exigent circumstances. That's under the constitutional law. That's the term when interpreting these cases that the Supreme Courts and the appellate courts do. And we call that, under the Missouri statute, imminent danger. If there's reasonable cause to believe the child is in imminent danger of suffering serious physical harm, in threat to life from abuse or neglect, or has been sexually abused, or is in imminent danger of sexual abuse. In those cases, the state doesn't have to wait to act until giving the parent due process. They can act first and then give due process later. And the example of that would be your 3-day protective custody hearing. Okay. Okay, so if state government can't interfere with the parent-child relationship without first providing due process, what does it look like in these actual cases? Well, I guess what we're going to talk about is it's going to depend on the circumstances, and we're going to look at a spectrum. We're going to look at the time the investigation is done all the way through to termination of jurisdiction and look at due process in those cases. So we're talking about a CAIN hotline where you put the perpetrator's name in the central registry, and for our purposes in child welfare cases, we're talking about parents. We're going to talk about removal of a child from the home. We talked about that a little bit just a minute ago. We're going to talk about juvenile court jurisdiction and what due process is when there's a juvenile court case. And then we're going to talk about permanency in terms of guardianships and adoptions where termination of parental rights has to take place. And we're going to find out that this due process applies in each one of these processes. Okay. So let's take a look at due process in child welfare cases, and we're going to begin with the CAIN investigation process. So in a CAIN investigation, due process means that the perpetrator's name cannot go on the central registry until they've been given notice and have an opportunity to appeal, which would be have a hearing at the CAIN or go for de novo judicial review. They have to have that opportunity first. So that's part of the due process. And then the state has to make their case. So now when we talk about the state making their case, we're going to talk about burdens of proof. And burdens of proof come in 3 flavors: who has it, what is it, and how much evidence does it take. So Children's Division is responsible by statute for the investigation, so they have the burden of proof. As far as what is it that the Children's Division has to prove in an investigation, we have to prove that the perpetrator abused or neglected the child. The third flavor is how much evidence does it take. And in this particular case, Children's Division has to meet the POE standard of evidence. That's called preponderance of the evidence. And on a scale of 0 to 100, we like to give that a number and call it 51%. And the reason for that is there's a legal definition for preponderance of the evidence. And it's that weight which is of greater weight than the evidence that's offered in opposition, or when taken as whole is more likely to be true. So, and we have a legal definition for preponderance of evidence. So in these cases, one side has to weigh more than the other. If you're on a fence and you can't decide which way something goes, then you probably have 50-50. But if you were to place a feather on one side, it would tip it enough that one side would weigh more than another, and that's how we get the 51%. So it's at least 51% in an investigation, and many times it's going to be a lot more than that. If Children's Division does not have preponderance of evidence of child abuse or neglect, then the case has to be unsubstantiated. Let's take a look at juvenile court adjudication process. Take a look at how due process and burden of proof play into this. Okay, the juvenile officer files the petition, so the juvenile officer has the burden of proof. So as far as the parents have to be, what is due process? Well, the parents have to be served with a copy of the petition. They have a right to tell their side, be present at the hearing and tell their side of the story. And then the division, the juvenile officer has to meet the statutory obligation under 211-031 in order for the court to take jurisdiction. So what is it they have to prove? Okay, the juvenile officer has to prove one of the 4 bases for jurisdiction. They have to prove the child has been neglected. And there's a definition under 211 for neglect that's slightly different than the one we use under 210. Or the juvenile officer has to prove the child is otherwise without proper care, custody, and control. And you need a factual basis for that. This is where a lot of times you'll see the juvenile officer plead allegations of abuse from one of our investigations. The third basis is the child is living in a judicially condemned structure. And I've not seen very many of those. You might see them in the bigger cities. And lastly, the child has mental health needs that the parent cannot afford or cannot access. So the juvenile officer legally has to be able to prove one of these 4 things in order for juvenile court jurisdiction. So how much? We've talked about who has the burden in a juvenile court case and what is it, but how much evidence does it take? Well, it turns out the juvenile officer has to prove his or her case by clear, cogent, and convincing evidence. And this definition comes from case law, and it's evidence that instantly tilts in favor of the proposition to be proved true. So again, if you're balancing and you think of preponderance of the evidence as you just need a feather to tip it a little bit, then evidence that instantly tilts in favor of the proposition to be proven true is much more evidence than preponderance of the evidence. And if you're going to quantify it on a scale from 0 to 100, 75 is a pretty good number. So if the juvenile officer does not have clear, cogent, and convincing evidence, the petition has to be dismissed and the child returns home. So hopefully the juvenile officer will have their information plus whatever information we've garnered in our investigation, and that will be sufficient to prove one of the 4 bases for juvenile court jurisdiction in the particular case. So we've done an investigation. We know what that due process looks like. Now we're looking at, we've adjudicated, we've seen what due process looks like in a juvenile court adjudication, because the whole purpose of adjudication is it gives the court a statutory basis to act and to make decisions for the ways the child is in need of care and treatment of the court, and to order services for the parents. So what happens when the child can't go home and be reunified? Let's take a look at what due process and burdens of proof look like in TPR hearings. Okay, first of all, the burden of proof, let's see, for a TPR hearing, either the juvenile officer or the division files the petition. Each parent, in order to have notice and opportunity for hearing, each parent must be served with a copy of the petition, and then they have the right to attend the hearing and be able to tell their side of the story. And the state must meet the statutory obligations under 211-447, and those are called TPR grounds. Okay. Okay, so burden of proof comes in 3 flavors. Who has it? What is it? How much evidence does it take? Well, it turns out that whoever files the TPR petition has the burden of proof. Usually that's a juvenile officer, or for the children's division that will be DLS. Just as an aside, this will also apply in Chapter 453 adoptions when you have the attorney for the prospective adoptive parent filing the TPR petition as part of an adoption action. So whoever files the petition is going to have the burden of proof, and then has to file the petition. Each parent has to be served with a copy of the summons. The juvenile officer has to prove in their petition that one or more grounds exist and that termination is in the child's best interest. So I think this is something a little different for us to hear in training, that there's actually some statutory requirements other than best interest if we're going to move to adoption on a child. The statute number is 211-447. So we're talking about the statute requires at least 1 TPR ground plus best interest. Well, what are TPR grounds? It turns out that the TPR grounds, there are 8 of them, and they're listed out for you. And one of those grounds have to be proven by the JO or Children's Division by clear, cogent, and convincing evidence. And again, it's the same standard of evidence that you use in the juvenile court adjudication. It's evidence that instantly tilts in favor of the proposition to be proved true. So I've trained these similar materials in multi-disc with a couple of different attorneys, and in courtroom skills some of this stuff comes up. And I've had 2 different attorneys who do a lot of TPRs tell me, and I did TPRs for 10 years, but they tell me that when they're staffing a case to determine whether or not there's enough evidence for a ground for termination of parental rights, they're almost looking for a higher standard of evidence called beyond a reasonable doubt. And if they're sitting down with the GAL and the juvenile officer and the children's division and talking about it, and those particular members of the team can't come to an agreement that this case needs to move on to adoption, or that there's TPR on adoption, that maybe there isn't enough evidence. So again, if you're not sure whether or not you have enough evidence to meet a TPR ground, then more likely you're at the 50% mark versus information that would instantly tilt, evidence that would instantly tilt in favor of the proposition to be true, which is that this TPR ground exists and therefore it would be in the best interest of the child. So just to mention these grounds briefly, because this is a big part of concurrent planning, which is the overall topic of the day, is these 8 grounds, a lot of them will match up with what's going on in your court cases. There's some exceptions, but abandoned infant would be a child under the age of 1 year, does not require a statutory period of abandonment, but the child has no contact or visitation with the child, although they're able to do so. An abandoned child is when the child is over 1 year and the parents have failed to have contact or visitation for 6 months or more, although able to do so. Failure to rectify. Failure to rectify is what I call the good social work TPR ground. It pretty much matches up with the court processes for the year where you hit the permanency hearing. You make a decision whether or not to change the plan and move on. And we'll talk about that when we talk about court processes. But that's the one that I understand from most of the training I've done with social workers, that's the TPR ground that they see the most. The next ground is child abused or neglected. Normally, for child abuse and neglect, that's why the kids come into care. And it's going to have to be some type of severe or recurrent acts of abuse, physical, sexual, emotional, committed by a parent or another that the parent knew about. Or it's going to be some type of continuous neglect. All of this requires a factual basis. Parental unfitness is another one of the TPR grounds, and this one we have information that sometimes would go to TPR when the parent has prior involuntaries, and we'll look at that. There are violent parental crimes against a child, which those are cases where you may want to opt out of reasonable efforts and go straight to TPR. Felony sex convictions could result in a TPR, and forcible rape. That would be a ground against usually a father who rapes a woman and then the woman has a child. Again, for that, a criminal conviction, since that's a very high standard of proof, which is that 98% beyond a reasonable doubt, that is considered very easy to do if you have a criminal conviction of forcible rape. Okay. All right, so we've talked a little bit about burden of proof on TPRs. The juvenile officer or children's division has it, whoever's going to file. They have to prove more than one or more grounds exist, and that it's in the child's best interest, and they have to do so, at least as to grounds, by clear, cogent, and convincing evidence, which is that 75%. Well, once that's done, then the court will look at preponderance of the evidence. Preponderance of the evidence is the best interest finding. So it's a much higher TPR ground as far as it relates to the actions of the parent. Once the court finds that a TPR ground exists, then the court will look at best interest, and best interest is that preponderance of the evidence finding, that 51%. So what's kind of hard in these cases is that if the JO or Children's Division cannot meet their burden of proof for both grounds and for best interest, then the TPR will not be upheld. We will lose at the trial level or we will lose at the appellate level. So the note at the bottom is just a reminder, again, that these same due process rights would apply in a Chapter 453 adoption. They may apply a little differently, but the overall idea of opportunity and notice for hearing are in there. Whether or not a parent consents also plays a role in that. TPR hearing on an Indian child. We need to discuss this a little bit because this has actually come up a couple times in the state of Missouri. Again, you've got the same basic right of the parents to notice an opportunity for hearing, and the juvenile officer has the burden of proof. But the burden of proof changes when it's an Indian child because federal law requires that termination grounds and best interest must be beyond a reasonable doubt. The other thing that we want to worry about in the TPRs is you need an Indian expert to testify in those cases. So they would be caught because of the amount of evidence required. They're a lot harder to do. If a parent is going to consent in a TPR, they also have to consent in front of a judge, and a record has to be made. A very strict record in compliance with the law must be made. Okay. One of our other concurrent plans that will allow for termination of jurisdiction is guardianship. And a lot of times when we're placing with relatives on the front end of the cases, guardianship becomes the concurrent plan as we go through the case. So what does due process look like in a guardianship case? Well, the attorney for the proposed guardians files the case. Each parent has to be served. They have a right to attend and tell their side of the story. So it's the same type of thing, notice and opportunity for hearing. And then the proposed guardians have to meet the statutory requirements for a guardianship under Chapter 475. So then what does the burden of proof look like? Again, who has it, what is it, how much evidence does it take? Well, the proposed guardian are filing the petition for guardianship, so they have the burden of proof. The statutory requirements under Chapter 475 is that each parent is unfit, unwilling, or unable to be the guardian of the child. And the standard of evidence is preponderance of the evidence, which again is that 51%. So an example of applying the difference in a termination of parental rights case and a decision for guardianship versus adoption, a good example is the incarcerated parent. A lot of times the parents are incarcerated and they're not going to get out for a number of years. Well, just the fact that they're incarcerated would make them unfit, unwilling, or unable for custody. So, and I think you can see that on this particular slide, because they're obviously unable. They're in prison and they can't get out, so they can't be a custodian for the child. But it's different in a TPR. The fact that they are incarcerated in and of themselves is not a ground for termination of parental rights. If we go back to that list of TPR grounds that we saw a little earlier, let's see. Nowhere on there does it say incarcerated parents. So incarceration in and of itself, even if it's going to be for a number of years, is not a ground for TPR. And the cases in Missouri, there are lots of cases that talk about it. And actually, we have to have evidence that meets one of these TPR grounds if we're on an incarcerated parent in order to terminate parental rights. Sometimes if they're the ones that abused or neglected the child, or they have one of these convictions against a child, there may be a TPR ground that way. A lot of times, though, there's an abandonment where they're not having contact or visitation or making any arrangements to. So you can make an abandonment case, and sometimes you can make a failure to rectify case. But that would require you to make efforts, work with the parents, include them in the meetings, which is not a bad thing. We've got new forms that are working with incarcerated parents. So let's go back to where we are. We just finished talking about to get the investigation and put someone's name on the central registry. We have to meet our POE standard when we make the finding at CAIN and in the courts if it goes there. For a juvenile case, again, we have to have enough evidence. We have to have that 75%. POE is only that 51. For juvenile court adjudication, you have to meet one of the 4 statutory bases for adjudication, and the amount of evidence is at that 75%. If you're going to move on through the process and the child is not going to be able to go home and be reunified with a parent, then we're going to look at the 2 legal permanency options of adoption and guardianship. And to terminate parental rights in order to get to an adoption, then we have to prove one of the TPR grounds exists by clear, cogent, and convincing evidence, which is that 75% number. And we talked about the 8 grounds just briefly. And then we have to, once we have that, then we can look at best interest, which is that 51%, on whether or not TPR would be in the best interest of the child. And then again, we're at that 75% mark. If you look at guardianship, we just have to prove that each parent is unfit, unwilling, or unable, and the fact that they can sign a consent is enough to get you there. But you can also do an involuntary guardianship where you have to prove that each of the parents is unfit, unwilling, or unable. And a good example is the difference it's much easier on an incarcerated parent to do so. So obviously, there's a lot of evidence that is involved all the way through the case. So just want to remind you that evidence drives the bus, and good documentation is what gets you on the bus. So basically what you're doing is you're practicing social work in an evidence-based legal system. So in order for the courts to make determinations of jurisdiction, in order for the court to make a determination of permanency where rights are going to be terminated and the child moves to adoption, or parents are going to be trumped and someone's going to be appointed, usually a relative, as the legal guardian, then quite a bit of evidence is required throughout the case. And since we're doing social work in an evidence-based legal system, all the good work we do with the families and all the good documentation that we provide is what will get us on the bus and get us to permanency. There's one more piece of legal fundamentals that we need to address in this training, and we're going to talk about the court processes in child welfare cases. So these are the various type of processes that happen from the juvenile court side, 211, 031, Chapter 211. Let's take a look at the various types of hearings that are held and why, and then let's go back through them and talk about what we are doing as the Children's Division during these same time periods. Because what I want to try to show you is that this is an integrated system. All of this works together. People are doing different things, they have different job responsibilities, but the whole process is an integrated process from both the juvenile court side and from the division side. So what happens? The child's removed from the home. Okay, we're going to start there with 0. That starts the case. Obviously, there's imminent danger if a child's being removed from the home. And within 24 hours, the court has to have an order of protective custody. So that's the second item on there. So the juvenile officer, although the child may be removed by law enforcement or by a doctor or by a juvenile officer on an authorization, the juvenile officer has to scramble, get his petition done, and get all that filed with the court and to a judge within 24 hours of the time of removal. Now, one thing we're not going to talk about in this particular training, because we don't have enough time, is there's also a way of having a hearing first and then the court taking protective custody at that hearing. And we're not going to talk about that. We're just going to talk about the court processes when a child comes into care because of imminent danger. So the child's been removed, an order of protective custody, the juvenile officer has to seek and get that signed within 24 hours. And then the next thing we have is a protective custody hearing. It has to be held within 3 business days. And that's that due process piece we talked about. So it's absolutely okay for the juvenile officer just to verbally notify the parents. Anytime they can notify them in writing, that's much better, but that's allowed. The next hearing type is the adjudication hearing, and these are in the order in which they take place in the case, and everything starts, all these time periods are from when the child comes into care. So the adjudication by law and by juvenile court rule has to be held within 60 days. Now, people use different terms depending upon the jurisdictions you're in. Some will call it a jurisdictional hearing. It has a bunch of different names. But what it amounts to is it's the hearing on the petition on whether the allegations are true or not that the juvenile officer has pled. Usually these cases are handled in the first 30 days because normally if the parents will admit to some of the allegations that amount sufficiently for jurisdiction, then the court will, based on those admissions, make a finding of jurisdiction and move on down the road. And the rules provide that if there's no admissions are taken, if the case is denied rather than admitted by the parents when they show up at their first hearing, then it's set for a contested hearing. But the idea is, regardless of whether the parents admit to something or whether there's a contested hearing on it, that should be done within 60 days under the juvenile court rules. My experience as a JO attorney for 8 years is that probably 95 to 98% of the time adjudication and disposition are held at the same time, and that the parents are admitting to something. Now, the statutes and the rules allow for a bifurcated process. Once jurisdiction's been assumed, then the dispositional hearing is all about what do we do with the family and the child. Is the child going to remain in the Children's Division custody and we provide services to the family? And again, probably most of the time, that's where the case will go. Reasonable efforts will be provided to the family towards reunification, both to mom and dad. Occasionally, there are one of the 2 or 3 situations that allow you to opt out of reasonable efforts and go straight to a concurrent plan of adoption or guardianship. But the dispositional hearing is all about what are we going to do with the child and the family. Now that the court has jurisdiction, what do we do? That has to be completed by the 90th day from the date of removal of the child. And again, like I said, adjudication and disposition can be held separately, or in most cases they're held one and then the adjudication, and then immediately following is the disposition. So the rules and the statutes allow for all of that. The next hearing type is a dispositional review hearing. And interestingly enough, the statute for the dispositional review hearing specifically states that the purpose of the hearing is to review the division's reasonable efforts towards reunification. So just so we're clear on that, it's our job to provide that information as far as what efforts have been made towards reunification, what reasonable efforts have been made. We put those in our court reports, we testify to them, and it's the court's job to review those at the dispositional review hearing. Now, each one of these hearings, just so you're aware, are covered under the Supreme Court rules as far as what the purpose of the hearing is, and what goes on in the hearing, how long it should last, what they should do afterwards, which is set the next hearing and move on. So what we want to do is make sure we're complete in our court reports to cover everything needed for these various hearings. So the dispositional review hearing, we talked about what it is. It's the purpose of the hearing is to review the efforts by the division, reasonable efforts. But how often do they have to be held? Well, it turns out they have to be held every 90 to 120 days during the first year of the case. The next hearing is the permanency hearing. So the permanency hearing, we all know, has to be held before the 1-year mark. And normally it's held pretty close to the 1-year mark. So for dispositional review hearing purposes, you're going to get 2 or 3 dispositional review hearings in if you're going to meet that 90 to 120 days. And some courts have much more frequent review of the cases than that. So when you hit the 1-year mark and you hit the permanency hearing, then what's going to be the permanency plan for the child? That's covered under a statute on permanency hearings, and it's also covered under the juvenile court rule. It's interesting to look at the new court rule on it because it talks about if reasonable efforts, if reunification has been the plan in effect, have the conditions or circumstances that cause the removal been corrected, can the juvenile be returned home? Or if not, whether a date has been established when the child can go home. Okay. If adoption is the permanency plan in effect, has the division made reasonable efforts to finalize the permanency plan in effect? Have parental rights been terminated? Have the parents been served or signed consents? Has the TPR hearing been set? Has an adoptive resource been identified? Reasonable efforts to finalize the permanency of plan of guardianship in effect. Has the guardianship resource been identified and the juvenile placed there? Or a date for placement set? When's the guardianship petition going to be filed, and a date set for the hearing? And those are the only permanency plans we're dealing with. The rule also provides for if the permanency plan is placement with a fit and willing relative, if that's the plan in effect, or if APLA is the plan in effect. These rules also, if you'll notice, the permanency hearing matches up with the federal statute, federal law, which requires that the permanency hearing be held. The next hearing is a permanency review hearing. It's required to be held every 6 months after the permanency hearing. So you have a permanency hearing at the 12-month mark. You have a post-permanency or a permanency review hearing at by the 18-month mark at the latest. And then your next hearing would be another permanency hearing, because you have to have those annually. Permanency hearings are annual hearings from the date the child came into care. The permanency review hearing is that 6-month hearing held in between the permanency hearings. And those are held until termination of jurisdiction because a concurrent plan has been implemented or because the child ages out of the system. Let's go back now and look at the court processes. And again, we're still on the same slide. What are we as the division doing during these same periods of time? Well, prior to the removal from the home, we're probably involved in the investigation and writing the affidavit or court referral letter that brings the child into care. The juvenile officer has to have an order of protective custody signed within the 24-hour mark, and at that point, we've had contact with the family. For some circuits, that would be an FST meeting where some of the professionals in child welfare are there. For other circuits, it's just contact with the family, and both of those comply with policy. If the adjudication is held at 30 days, because summonses are usually issued for 30 days with a hearing date for the parents to show up. So we all know that at the 30-day mark we're having, or prior to the 30-day mark, we're having a family support team meeting. So again, if you can schedule that within time of when the adjudication is going to be, everybody should be on the same page. If the disposition is not held at the same time, it's held by, well, let's go back to adjudication. If the adjudication is contested, then it needs to be done by the 60th day, and we would be having another FST by that 60th day. Again, a chance for all the team members to be on the same page when you go to court. Once the adjudication is complete, and disposition may be done at the same time, or at the latest, the disposition has to be held by the 90th day. So in most counties, if the circuits are having FST meetings monthly, which is a little more than is required, but if they're having them monthly, then you'd want them to have another meeting before the 90th day if you were going to go to court for a dispositional hearing. Next, we go to the dispositional review hearings. We know they have to be every 90 to 120 days after the adjudication and disposition are done. So at a minimum, 90 days is 3 months, 120 is 4. At a minimum, the court's probably going to set a hearing for around the 6-month mark. They may set it at 4 or 5 months, 3 or 4 months. It depends upon your court, but at a minimum, you'll have at least one hearing by the dispositional review hearing prior to the 6 months. And at the 6-month mark, we have to have a PPRT. We'll have 2 or more of those dispositional review hearings before you get to the permanency hearing. And in those circuits that have regular FST meetings, it's good practice to have an FST before the court, even if you don't have regular FST meetings. If you can have one before court hearings, again, everybody's on the same page. It gives you a chance for everybody to know what's going on before you go to court. So the permanency hearing is held at the 1-year mark, and at that point we have to have a PPRT. So again, all these different hearings match up with FST meetings, things that we are doing. If the permanency plan has not, the permanency plan or concurrent plan have not been implemented at the 18-month mark, then there's going to be a permanency review hearing. And again, at that 18-month mark, that would be when we have to have one of those PPRTs. So, and that process continues through termination of jurisdiction. So as you can see, all the way through the process, the series of court hearings match up a lot of times when we're having a PPRT or an FST meeting or contact with the family. So, and I missed the protective custody hearing. That has to be held in 3 business days, and the Children's Division has to have their 72-hour FST by law within 24 hours, either before or after the protective custody hearing. There's an actual statute on that. So these all match up on how the processes for the court and for the division work. Well, let's move on and talk a little bit about permanency plans. Because to get to concurrent planning, we have to look at all these legal fundamentals, look at these court processes, add some permanency plans, stir it all together, and talk about concurrent planning. It's kind of a way to put the whole system together. And the permanency plans we're going to talk about are reunification, adoption, and guardianship. And that's because the scope of today's training is limited. We've only got a couple of hours, so we can't address everything. Okay. So let's look at reunification. We're going to start with that. Okay. Reunification is not just with a parent from whom the child's removed. You work reunification with both parents. One parent doesn't have a plan of reunification and the other a concurrent plan of reunification. They both have constitutional rights. You work with both parents at the same time to return the child home. Just want to remind you that a lot of times our kids are removed from one parent households, and a lot of times it's from the mother, not the father, and we tend to talk of non-custodial parents in general. Maybe what we need to talk about is non-resident parents, especially non-residents' fathers, just because they're not in the home or they're not in the state or they're incarcerated, or maybe we don't know anything about them. A lot of times, before kids come into care, we work family-centered services cases where we provide services to the intact family, and we provide IIS services, intensive in-home services, to the intact families. And hopefully we're doing genograms and inquiring about the parents during that, non-resident parents during that period of time, because they may be a valuable person to the FCS plan before the child comes into care, but we're going to have to deal with that parent if the child does come into care, and because kids have two parents. Okay. Diligent search, I believe, is the next. The division has a diligent search to identify and locate parents. That's 210-127. We're required to do so until relieved of the court. We have to report the efforts to the court at every hearing until the parent is identified and located, or the court relieves Children's Division by order. Okay. Why is it important? It's important because the identity of a parent may lead to an unknown parent for purposes of reunification, but it may also lead us to relatives for placement and for concurrent planning. Also, don't forget, children also have a constitutional right to a relationship with their parents. Okay. Well, what do? We need to talk about parents just a little bit more, because does the known parent always bend over backwards to help us locate or identify that unknown parent? No, they don't. And sometimes mom doesn't want dad to know. Sometimes mom doesn't want the child to know who dad is. Sometimes mom doesn't know who the dad is. Or sometimes mom's embarrassed about how the child was conceived. Or maybe mom has lied about it for years. Or maybe dad knows where mom is, but does, for the same reasons, doesn't want dad to know, and doesn't want dad doesn't want mom to have company or to have custody of the child. So sometimes it works both ways. It could be either parent. But when we make all these diligent efforts to locate these parents, we can't just do it once. We need to continue it throughout the entire court process until relieved by the court, until we find them or identify them. And when we can't get cooperation out of the parents, then maybe we need to be asking the court for help. There's nothing that says you can't report to the court that the parent won't provide you with that information. And the judges can handle that differently. Some of the judges will say, parent, I'll give you a week or two to get with the worker and tell them about the other parent or who it could possibly be. And then say, if you don't do that, then worker, I want you to let the juvenile officer know. We'll get another court date set, and then I'll put the parent on the stand to testify. And some of the other judges will just directly say, okay, parent, I'm putting you under oath. Tell me about who the mother is, or tell me where the father is, who the father is, where the mother is. And the court will ask them directly. So if you need that help, it's pretty important to go ahead and get that information, because the last thing you want is what happened to me that one time, where you file the TPR, you publish on a street name, all you have is a first name on the father, no other information, and then that father walks into court on the day of the TPR and says, hey, I saw that in the paper, I may be dad, I may not be dad, but I don't know whether I am or not. I want paternity testing, and if that child's mine, I want it. Luckily for us, although he was dad, we were at a later date able to do termination of parental rights. Okay. We don't want to forget about the non-offending parent, who's I think this was a statute to remind us that just because a kid comes into care from one parent, that we don't have to look at the other parent. The statute basically says for the non-offending parent, they have to be entitled to physical custody. They're not the subject of the investigation, and whether they've been living together with the other parent or not, they're willing to kick that other parent out or not allow them contact with the child. They're also asking the court for custody, and they agree to go along with whatever the court orders regarding visitation or contact with a non-offending parent. And part of the reason to remember this is sometimes those other parents, there are no safety issues that prevent placement with them, but the bar goes up when the juvenile case goes into effect, and it takes them a long time to get custody of their child. Now, are there problems too sometimes with these cases where we've got a non-offending parent? Sure there are. Sometimes there's paternity testing and you know their dad, but they're not on the birth certificate. There's no legal way that you know their dad. And sometimes they don't have the money immediately to go get paternity, to do a paternity case, or to do a custody case, or to modify existing custody orders that are in place. So, despite this non-offending parent statute, the end of the statute says, despite the statute, the courts in the division have the discretion to place as they deem appropriate, just so you know that that's part of that statute. The last thing we're going to deal with, I think, as far as actual that really affects reunification with either parent, is the prohibition on reunifying or placing a child in the home of a parent or in the home of a parent where another has this type of felony criminal conviction in Missouri on any child. So the nice thing about that is to understand that that statute is well written in policy, and that all of the criminal convictions are listed. Most of them are felony sex offenses against a child or human trafficking type offenses. There are some limitations on the statute. What's really important is to make sure that if you think you have that prohibition, it only applies to juvenile court cases that are filed on or after August 28th of 2004. And sometimes how those apply, you may need to check with DLS on the interpretation of the statute if you have any questions on it. Okay. Now there's some other things we do while we're working reunification. And one of those is we make reasonable efforts to place and keep siblings together, and that's federal law. And the statute, the federal law, basically says the Children's Division has to make reasonable efforts to place the children together unless it's contrary to the safety or well-being of any of the siblings. So it's almost like they're already assuming that it's in the best interest of the child to be placed with siblings. But it has to be contrary to the safety or well-being of any of the siblings if we're not placing the siblings together. And the statute provides if they can't be placed together, then the Children's Division must provide frequent visitation or other ongoing interaction between the siblings, unless it would be contrary to the safety or well-being of any of the siblings. The statute also requires the division to document the reasonable efforts that are made to keep the kids together. And for if the siblings are going to be split, then administrative reviews, the Children's Division are required on a regular basis. Now, there is a placement chart out there on the internet with policy that talks about applying constitutional laws, federal laws, and Missouri laws on placing with grandparents and trying to make them all work together. So if you've got a parent who hasn't done anything wrong, they should be entitled to placement of their child if there's no safety risks. And again, there's lots of exceptions to all these rules. This is just a very general conversation to talk about it. Then you would apply federal law. One of the federal laws is on the sibling placement together. So if a parent is fit and they don't have anything against them in juvenile court that would be a safety issue or would keep the child from having placement, then that child would go with their parent. If there are other siblings that have a different parent that's a non-offending parent, then they might go with that particular parent. But once you get past the parent level, then you're looking at keeping the siblings together. So if one of the parents is a non-offending parent and the father of the other kids is, then maybe you're looking at, could this parent of the one child take both the kids and keep them together? You're going to try to make the federal, the constitutional, federal, and state law work together. If that's not going to happen, then you're going to be looking at, are there grandparents that will keep these siblings together? Because the federal law is above the Missouri law in terms of you have to keep the siblings then together. And then to make it consistent, you're going to look at, are there grandparents out there that will take all of these kids and keep them together? And then your analysis works from there on the various state laws that apply. Okay. Let's see. The next one is, also while we're working reunification, we have to comply with ICWA requirements if we have an ICWA child. So Indian Child Welfare Act applies. If we have an Indian child, then we need to be notifying. It's very important to notify the tribe, and we have to comply with the placement requirements. There's a placement preferences based on what where the tribe wants the child placed, and you can have a child in a foster home for a period of months and be late to the game notifying the tribe. And even though there may be some bonding that has been exhibited between the foster parents and the child, if it's an ICWA child, then the federal law applies and that child goes to the licensed Indian home or to the relatives based on the preference of the tribe. One of the other things that we have to do is make diligent efforts to locate, contact, and place with a grandparent or other relatives. We'll talk a little bit later in the statutes about this, but the big one is the 3-hour requirement to identify, locate, and place with a grandparent once a decision is made for emergency placement. At that point, we can go ahead and place with a foster parent if there's no grandparent available, where you can run the CAIN check and the criminal check and make sure they're okay and do the walkthrough that you do before you place with them. But that diligent efforts don't ever go away. We're required to continue diligent efforts to contact, locate, and place with a grandparent or other relatives. And the last thing that I just wanted to mention up front under reunification is we're also complying with the ICPC. ICPC applies because you've got children traveling across states to be placed with relatives or other for placement purposes, for adoptions, and for guardianships. So that is another one of the laws that applies. Let's talk about the permanency plan of adoption. Okay. Adoption is a legally binding permanency plan. Parental rights may be terminated separately in a Chapter 211 proceeding, or they can be done as part of an adoption proceeding under Chapter 453, and we're seeing a little bit more of that done across the states. Parental rights may be terminated voluntarily, by consent, or involuntarily. The statutes allow for that, but you have to get through the TPR piece if you're doing a Chapter 211 TPR before you can get to the actual adoption itself. And then when we were talking due process early on in the beginning of this training, we talked about at least one TPR ground has to exist plus best interest in order for there to be an involuntary TPR under Chapter 211. That's 211.447.6. When I talked about rights being terminated voluntarily by consent, that statute number is 211.444. Okay. I think we saw this earlier today. Best interest alone is not going to be enough to get you a TPR. And newsflash, some of the judges are going to require TPR on any man who's been named as the child's father. And the reason for that is these judges, or that's been my experience for the 10 years I tried TPRs, is that the judges want a nice, neat package tied up in pretty paper with a big red bow and handed to the adoptive parents on a platter that nothing's ever going to be overturned or go away. And in order to do that, they're going to be looking at all the different men that may be a father, because sometimes there's more than one to which there's some type of legal rights as a parent that attach, and that kind of triggers those constitutional rights that of due process that have to be taken care of as to each parent. So the best example I think of that is the man who's married to the mother at the time of the child's birth, but guess what? He's not the bio dad. You do some paternity testing, you find the bio dad. Now you got these two men, both of them have legal rights to the child. And the way the statutes seem to be currently written, you would have to terminate on both of those dads. And if you have to terminate on both, then the statute requires at least one ground plus best interest. So keep that in mind when you're working with the husbands of the mother at the time of the child's birth. A lot of the time, by the time you get to TPR, if not earlier, that presumed father, the term is presumed father, will usually sign a consent and go his separate way. It's not very often that you have one of those presumed fathers who's not the bio dad who want to fight and get placement and custody of the child, and your plan is something different. That doesn't generally happen. Okay. So I think I've covered everything on there. The other thing we have to talk about on adoption is that there's some funky things that go on in the adoption, the TPR judgment statute. And we know we have to have grounds plus best interest, but there's also this TPR judgment statute. And it talks about how one of the options the judge has is the judge can find that the judge may find TPR grounds against a parent, but the judge is able to find that TPR is not in the child's best interest if the child is over 14 and objects to their parents' rights being terminated. And that statute number is 211.477.4. For the TPR, there's no written consent required of that child that's 14 or older, but the courts are going to be looking for some evidence that the child's in agreement with the TPR if they're 14 or older. You don't necessarily have to put them on the stand, but someone needs to testify that this is the plan the child wants. And if you've had a permanency hearing and the child is 14 or older, then under federal law that the child has consulted with the judge has consulted with that child in an age-appropriate manner as to the permanency plan and may already have information to realize that the child is wanting to be adopted. Now, one of the other things that under adoption is that if the child does have to consent when it comes time to be adopted if they're 14 or older. So it kind of makes sense. The adoption statute matches up with the TPR statute. The judge isn't necessarily going to grant a TPR if the child's 14 and older and doesn't want to consent or doesn't want their parents' rights terminated, because guess what? Are they going to sign a consent for adoption? Then once their rights are terminated, their parents' rights are terminated? No, they're saying they don't want that done. So why would you make a legal orphan? It makes sense that the statutes match up, and you want to know about if the child's going to be 14 or older, whether or not they're going to object to the TPR on their parents, because they're going to have to sign a consent when it comes to adoption, and that's 453.030. Just so you know, there's a new law, 453.030.2, that requires the GAL to ascertain the wishes of the child for adoption if they're under age 14 in an age-appropriate manner, and the court considers that in making its decision regarding whether adoption is in the child's best interest. So that was something that was added last year. We also know that in order to finalize an adoption under the adoption statutes, there has to be a finding made in the adoption that the particular case complies with the Indian Child Welfare Act, which means if you're not looking for an Indian child up front and don't ask the questions and jump through the hoops required under the Indian Child Welfare Act for notice and preference early in the case, this may come up to bite you when you're trying to finalize an adoption. And I've had workers talk about how a parent's willing to consent to termination of parental rights, and they're sitting there reading the consent form, getting ready to sign their rights away, and they get to that line near the bottom of the first page or on the second page that says, I'm not a member of an Indian tribe or Eskimo village, and they go, oh, but I have Indian heritage. Well, everything comes to a stop at that point, and you've got to deal with the ICWA issue before you can move on. And that's true when you hit the adoption too. So the ICWA needs to be taken care of up front. If the TPR is done, ICWA needs to be dealt with in the TPR, and then it has to be complied with for the finalization of the adoption. And that's 453.080.1 paren 6. Lastly, to finalize an adoption by statute, the court also has to comply with ICPC. So if a child's being placed out of state and is going to be adopted, or guardianship out of state, then there's a lot of requirements. We need to remember that the purpose of ICPC is to make sure our Missouri kids are safe when they're placed out of state, and remain safe and receive services when they're adopted, and there's guardianships that are done out of state. So that's the whole purpose of it. The problem is if we're not working at getting through all the paperwork in order to get the ICPC taken care of, then we cannot finalize an adoption until all the I's have been dotted and all the T's have been crossed under ICWA or ICPC. Okay. Now, we've been talking about adoption, and we know we have to have grounds plus best interest, but we really need to talk a little bit more about TPR grounds. And really, the only ground we're going to hit on in any detail is going to be the failure to rectify ground. And that's because that's the ground that I hear from the workers in the trainings I do. That is the one that is used most often when they go to TPR, this failure to rectify ground. So you have, as one of the handouts that came with your materials, the TPR grounds under 211-447. And what you have is a list of the TPR grounds. Each one of these 8 grounds is listed, and then underneath it you have a set of what we call elements. So each one of these TPR grounds comes in paragraph form under 211-447. And then what I've done in the form that you have is I've broken them all down into elements to try to make them a little bit more understandable. These grounds are very complex, and these lists of elements are just intended to be an overview of the general requirements for the various TPR grounds. Some have some complex requirements that you can talk to your supervisors about who've been to my legal aspects training on family-centered and adoption cases, where they actually receive quite a bit of training on all these elements of TPR grounds and what it takes. Other than that, you would need to talk to DLS if you have any questions regarding termination of parental rights. So, having said that, that's the attorney in me. That's part of my job. Let's take a look at some of these TPR grounds. To begin with, abandoned infant and abandoned child. The big difference is that there's no time requirement of abandonment on the abandoned infant. The child has to be under the age of 1 at the time of the filing of the petition. The biggest question I get on abandoned infant and abandoned child is, well, what if the parent calls me? Or what, I've talked to the parent a lot, is that abandonment? If you'll notice, it's no parental contact with the child and no support. So your count of time in terms of abandoned child is contact with the child. You're going to testify on abandoned infant to the lack of contact between the parent and the child. If they've called you, then that will give you some evidence that the parent is able to have contact with the child. And that's the third element for abandoned infant, or the fourth element for abandoned child. Just real quickly, violent parental crimes against a child. That's the child, and the parent of the child in this TPR has to be convicted of one of the following offenses where another child of the parent was the victim. So these look like criminal offenses. The statute is not really actually written for convictions, but they are terms of art, criminal terms of art. Therefore, the recommendation is you want to have a criminal conviction on these areas. Okay. Let's take a look at failure to rectify. Okay, remember how we talked court processes. This is to kind of help you understand the three elements that are required for failure to rectify. So if you see there's three of them listed there: juvenile court jurisdiction for a year, harmful conditions that brought the child into care or other harmful conditions, and thirdly, that these conditions cannot be quickly corrected for reunification. So let's go back to that list of all the court hearings. I want you to think about it, or go back and look at your list of the court hearings. The child comes into care, they're going to, and by the permanency hearing, we will be at the 1 year mark. And the permanency hearing is where we usually change our plans to adoption, there or after, depending upon the facts of your case. But at a minimum, most of the time, at least for a failure to rectify, you have to have juvenile court jurisdiction for the child for over a year. So again, this is the social work TPR ground because the time requirement matches up with the basic pattern of efforts towards reunification from the time the child comes into care to that first year to that permanency hearing. Secondly, the second one talks about the harmful conditions which led to custody. Okay, we were doing the investigation most likely. We know why the child came into care, and the court will have adjudicated on why the child came into care. There should be a factual basis in the petition for juvenile court jurisdiction and in the judgment. And you're going to be working reasonable efforts to alleviate or remove the conditions which brought the child into care. That's part of reunification. So again, at the end of the year, if you've done all that and the child can safely go home, then you're going to be out of the case. And there may be some cases where you continue to work efforts with the parents beyond the 1 year. But there are also cases where at the 1 year mark, the recommendations are to change the plan. So, and that will be based on the fact that the harmful conditions that brought the child into care still exist. There's an or here. It can be based on other potentially harmful conditions that exist. So here's the example. 3 kids come into care for a filthy, dirty, unsafe, and unsanitary house. I mean, just absolutely filthy to the point where there are safety concerns for the three children. And they're 8 and under. One's 18 months, one's maybe 5, the other's 7 or 8. And the kids come into care. Well, after you adjudicate on that filthy, dirty, nasty house, and it took around 60 days to get it adjudicated, then you find out that allegations start arising from talking to these kids, or the kids are with therapists, about sexual abuse. So then you find out these kids have been sexually abused. So at least in the circuit I worked in, we would usually adjudicate on the allegations of sexual abuse. You give the parents full due process, serve them with what it is they've done bad, have a hearing, and they can admit to the allegations, or you can have a contested hearing, and then the court makes a finding on those. Well, in this particular case, we did that. So by the time we got to the 1 year mark, we're still on element number 2 on failure to rectify. By the time we got to the 1 year mark, the parents had cleaned their house up. So they thought the permanency plan should be reunification and they should get their kids back. And we were saying, oh, no. You've done nothing about this sex abuse. It's been adjudicated that these 3 children were sexually abused. So they are very potentially harmful conditions that are still existing at that 1 year mark at the permanency hearing. So although we no longer had the beginning part of element number 2, we had the second part. So you can have the first part where the conditions that brought the child into care still exist, or you can have the second part where there's some other safety concerns that are potentially harmful that now exist, or you can have both. And then you also have to have the third element. These conditions cannot be quickly corrected for reunification. There's an or here too, but I'm really going to focus on this first half of number 3. What are we doing at the permanency hearing? What have we done at all the review hearings all the way through the case? If you remember, the dispositional review hearing's purpose is to review all the reasonable efforts the division has made towards reunification. So usually when you're at the 1 year mark and you're ready to change the plan to something else besides reunification, then pretty much my experience says that you've provided all the efforts you have, and despite those efforts, these kids can't safely go home. And because you've provided all those efforts, are there any others you can offer? Probably not. You can continue to provide services, but unless it's one of those cases where the parents are making some pretty significant progress, so that it would be worthwhile to continue reunification because they've got a good chance of going home. If your facts show that you tried to provide all these efforts and despite that, all those safety concerns still exist, then do you think those conditions can be quickly corrected? 2-3 months or so? Probably not. That's how you make element number 3. So that's how failure to rectify is a good social work TPR grant. Only I kind of feel like a commercial where they want to sell you one thing and then they say, but we're not done yet, and then they'll half the price and then they'll sell you twice as much merchandise for half the price. Well, we're not done yet. For failure to rectify, the court has to look at all 4 of the following factors, and at least one factor has to support TPR. If you think about why the kids come into care most of the time, there's something going on in the family, but the underlying causes are mental health issues, or their chemical dependency issues, or domestic violence, and it's all exacerbated by poverty. So if you'll look at the 4 factors, the first one is if it's a severe parental mental condition such that the parent is unable to parent the child. The second one is untreatable parental chemical dependency. I know social workers don't like the term untreatable. And the case law under that pretty much talks about multiple attempts at trying to fix the parent's chemical dependency. And then you hit a point where the court says it's not going to be able to be fixed in a short period of time, and we're going to treat it as untreatable, especially if the parent refuses any further services towards treatment for chemical dependency. The third one is just a straight TPR case for failure to rectify under that good social work ground, because surprise, we're looking at the social services plans and the extent of parental compliance. And we just kind of talked about that up on element number 3. So you're going to show all the different social service plans that you've worked and all the services you've worked, whether they're court ordered or whether the team agreed to it. And then you're going to show how the parent complied and how they didn't. And you want to focus on everything the parent's not doing that they're supposed to be doing, but the biggest fish out of the whole bunch are the safety concerns, because sometimes parents visit, or maybe they get a job, or maybe they get their house together, but they don't do what they need to address the safety concerns, so the children can't go home. So again, when you have a failure of the service plans and extent of parental compliance, especially if it's going to safety issues, then you may be able to make that factor. Again, all of these have additional information under the case law that goes with them. The fourth choice is the success or failure of efforts to aid the parent to change. So the focus is not on the fact of how we aided them. The focus is on the fact that we provided all these services, and how did they interfere with, or what were their reasons for not complying with the change. Okay, let's see. So let's take a quick look at the factors in a little more detail. Again, we looked at the 3 elements on failure to rectify, and we've looked at the fact that and you have to have all 3 of those factors. And then now we're looking at the 4 factors, and the court has to have at least one of the 4 factors. So let's take a little bit more in-depth look at mental conditions and chemical dependency, because there's a lot of cases here where the cases get lost. Just because a parent has a mental condition will not get you a TPR. Just because a parent keeps testing dirty, it will not get you a TPR for chemical dependency. It takes a lot more evidence than that. So for mental condition, all 3 of these elements are required. It has to be a documented mental condition, which means you're looking at a psych eval, and the courts are probably going to want a pretty new one. Duration. The condition has to be permanent or not likely to be reversed. And a lot of those are your Axis 1 and Axis 2 diagnosis under the DSM-4. And I don't pretend to be a psychologist, although I put a whole lot of therapists and psychologists on the stands over the years. But we're probably looking at Axis 1 and Axis 2 diagnoses. You're dealing with personality disorders, bipolar, schizophrenia. It goes on. It can even be depression if it's severe and chronic. something that's so debilitating they can't care for their children. But I don't want to limit the scope of it. It's going to depend upon what the evaluation shows you. How do we know that the condition is permanent? Well, most of the time when the evals are done, parents will get asked for a history, and they'll provide information that shows their condition goes back many years to when they were teenagers, something like that. And that helps you understand whether or not it's permanent. So it takes the DSM-IV piece, and it also takes the history piece to help you with that. Not likely to be reversed. Can it be treated? If it can be treated, we all know what type of chemicals we're talking about and how hard it is for the parents when they're being treated and starting to feel good, then the side effects of the medication really bother them. And it's hard to keep them stabilized on their medications. And then severity of effect is the big one. The condition is so severe the parent's unable to knowingly provide the necessary care, custody, and control. There's kind of a spectrum here that I like to talk about. If a parent their mental condition is so serious that they can't take care of themselves, then obviously they can't take care of the child. So if they're not clean and they're unwashed and they smell and they can't get anywhere and they don't have anywhere to live and they're in and out of shelters all the time, or whatever factual basis you have that shows because of their mental condition they can't even take care of themselves. They may be so low functioning that they can't make decisions for their own health and safety, their safety and well-being. They may have the public administrator as their guardian. In those cases, those are for sure the severe mental conditions we deal with. On the other end are the conditions where the parents just act out and do a lot of things that cause you a lot of problems in your team meetings and are trying to get the kids home, and you can't necessarily get them to do the evaluation to find out what's wrong with them. Then you've got a whole spectrum in between. But the really important thing is you have to have facts to show that they can't take care of their kids. You'd have to know that. And a good way is, what's the relationship for visitation, services, can they care for the child, can they be consistent? You just have to look across that spectrum and try and decide whether or not they can provide the necessary care, custody, and control. And a low-functioning mom, if she can't read the clock and she can't make formula and doesn't know fractions or numbers, it would be very hard for her to care for a baby. Chemical dependency. This is the second factor, and again, you have to have all three elements and one of four factors. So for chemical dependency, what's required is a parent has to have a chemical dependency, so you need something diagnosed that cannot be treated and prevents the parent from providing the necessary care, custody, and control for the child. And one of the good cases that I like to use in one of the other trainings I do on this, there's a case where the chemical dependency factor was upheld. Mother had a number of convictions for criminal cases based on using drugs, selling drugs. She also had, 10 or 11 inpatient, outpatient drug treatment attempts that didn't work. And they had a timeline with all the different inpatient and outpatient treatments that the parent attended. In that particular case, the parents wanted 3 extra months because she felt like she was doing better and therefore her chemical dependency was treatable. And the court said, after all these attempts and the fact that she tested, dirty 16 out of 40 times and actually tested positive on the day of the TPR trial, the court said, from that we can infer that you're not going to benefit from any more treatment in the short run, and therefore found that it could not be treated. And then again, you have to show how is it they're unable to take care of themselves, so they can't take care of the child. A lot of times, if you look at a timeline between the number of times they're in jail, inpatient, or in prison, it will be a large part of the child's life, and there's no reason to think that that will change. So you have to have one of the 4 factors. Again, we've talked about mental condition and chemical dependency. The third one is social service plans and the extent of parental compliance. You have to identify the written service agreements and their terms when determining that. One of the really important things is if you're not working services and you've only got maybe one written service agreement, then you're probably not have made reasonable efforts in order to be able to make this particular factor. And again, the case law talks about if a parent's making progress in complying with a written service agreement, it doesn't have to be full or substantial. I would again recommend to you that you have facts on how they're not making progress on the safety issues that brought the child into care and whether those have been rectified. Okay. On the factor of the success or failure of efforts to aid the parent to change, you have to identify the specific efforts made by the state and the parent's cooperation or hindrance with respect to those. We've been talking about the permanency plan of adoption. Now let's take a look at the barriers to TPR and adoption. First one, parents. The absent parent search law requires us to look for parents that are known but can't be located or unknown. Failure to diligently search for a parent can be a barrier to TPR. Because remember, our parents have due process. They're entitled to notice and opportunity for hearing. So if we haven't looked for that parent or we don't know where they are, then by the time you want to change the plan to adoption, we're no longer going to be able to go straight there because we haven't located them. Another thing is I cannot tell you how many TPRs I've done where I'd get the information from the file, the referral, read through all of the information in the narrative, and guess what? You'd come up with some information on the parents. Or when I would request the juvenile office or the division to do an affidavit of all the efforts they made to locate parents. This was before the statute went into effect that requires the division to do these absent parent searches. But in the process of writing their affidavit, they'd find out information on the parent, and then we'd be a year into the case and we'd have a parent now that we'd have to deal with. And the last thing you want is to publish on a parent and then have them walk in the courtroom at the TPR and say, here I am, I know you're 15 months or more in the case, but I want my child. I want paternity testing and I want my child. So that can be a barrier to TPR and adoption. The parents have constitutional rights. They are entitled to their due process, and there may not be a ground for TPR on the parent if they're untimely located or identified. Another barrier to TPR and adoption is relatives, but relatives in terms of we may not be finding them or locating them in a timely basis, as we're required to do under 210-565 and 210-305. So, untimely identification or location of a parent who's entitled, a relative who's entitled to placement, it may change the placement situation. The preference for relative placement does not have an expiration date. There's also the 9-month preference for placement for foster parents who want to adopt a child under 453.070.7. And what you end up with are 2 Missouri preferences laws, and then the court has to make the decision. So, we talk about the judges and their black robes up there on the bench. I really think they ought to wear a black and white striped jersey and carry a whistle for the types of issues that they have to deal with in our cases. But it's really important that throughout the case we're looking for relatives, that we're documenting the attempts to find them, and that we're working with placements with relatives. Another possible barrier to TPR and adoption can be the Indian Child Welfare Act. And let me ask you while you're listening to all this, gee, aren't these the same kind of things I heard when we were talking about reunification as a permanency plan? Well, I guess what I'm here to tell you is all the good work that you do in compliance with the law on the front end of the case will help you get to your concurrent plan if the child does not go home. But it will also, if you don't do that good work and we're not searching for parents and we're not placing with relatives and we're not following ICWA, then that can be a barrier to achieving a permanency plan of TPR and adoption. What happens with noncompliance with ICWA? If you fail to notify the tribe when an Indian child is involved, it could deprive the court of jurisdiction. They can trump out and have tribal jurisdiction, or it can overturn a TPR and adoption that's already been done. Again, TPR grounds in a TPR case on a ICWA child is beyond a reasonable doubt as to grounds in best interest, and a qualified expert is required. The other, another barrier to TPR and adoption, guess what, is ICPC. And I think we dealt with this a little bit on the front end too. How long, when I ask in various trainings that I do, how long does it take to complete the application for ICPC to place a child out of state? And I get told 3 months or forever. And then I ask, well, once you get the application completed, how long does it take before you get approval from the receiving state? And they'll say more than forever. Well, then don't forget that under the law, in order to finalize an adoption or guardianship, the child usually has to be placed by law in that placement for at least 6 months before the receiving state will agree to the finalization of the adoption or guardianship. So you've got 3 months or a long time to get the application done, forever to get it approved by the receiving state, and then 6 months on the back end. So one of the big problems we have is you want to make sure that if you're going to do ICPC, those approvals are good for 6 months. So why not apply early and often? That would be Mary Kay Cleathermos's recommendation to you. And the concept I've been talking about is sequential planning versus concurrent planning. You don't want to wait until you're at the permanency hearing or till you have your PPRT right before the permanency hearing, decide to change the plan to adoption or guardianship with an out-of-state relative, and then have to begin all the paperwork, because you'll sit probably a minimum of a year before you can implement that adoption or guardianship. Okay. Some of the other barriers for ICPC include untimely or incomplete requests that are filed either through our state office or with the receiving state. And again, Missouri law for adoptions has to comply with ICWA. If you remember, that's one of the findings that has to be made. Another barrier to TPR and adoption would be problems with older youth. Remember, the judge has the option not to grant a TPR and to find that it's not in the child's best interest if the child is 14 or older and doesn't want their parents' rights terminated. And then again, that same child must consent in writing to adoption if 14 years of age or older. So you want to really be thinking seriously about TPR when the child hits about 12 and a half as to whether or not the child is going to want this to happen or not. And on those youth where they don't want their parents' rights terminated, is there therapy or some other services you can provide them to help them with dealing with the issues that are raised by when they age out of the system, and what their lives will look like, and who will be their parents, and where will they spend their holidays. So, another one is lack of adoptive resources. Although the 211-477, that TPR judgment statute, allows the court to terminate parental rights whether or not the child's in an adoptive placement, many of the judges and the juvenile officers are reluctant to make legal orphans out of these children. So, now again, the fact that the child is not in an adoptive placement is not a legally sanctioned, federally sanctioned, compelling reason under the Adoption and Safe Family Act. So you may still have to make a referral to DLS as to whether or not there's TPR grounds that exist, and if it would be in the child's best interest. So one of the problems also, if you wait until you have the adoptive resource to do a TPR versus doing the TPR early and not having an adoptive resource, and maybe the child doesn't get adopted, is that sometimes with TPR grounds and the way the case law works, especially since the KW case in 2004, is sometimes there's just a window of opportunity, for lack of a better word, where you've provided all the services you can provide, and you have current information on the conditions of the parents and how they continue to be harmful to the child. So you have the information that it would take to provide the evidence to make a TPR. But if you have a court that's not willing to do the TPR and you wait until you have an adoptive resource, you may no longer be providing services or know what's going on with the family members. There may not be enough evidence for a TPR grant. So it kind of works both ways on that, and you just need to be aware of that. Okay. One of the biggest things we need to talk about as far as the barrier to TPR is reasonable efforts. Sometimes failure to make reasonable efforts towards reunification or document it to support a TPR grant. The really important thing is I think all the good work is being done, and it may be documented, it may not be documented, but we're not always clear on what it takes to make a TPR, so all that good documentation doesn't make it into the TPR referral or doesn't make it into the trial record, and so the TPRs are not being upheld. Also, there's the need for continuing reasonable efforts towards reunification until the trial court terminates parental rights. This does not work with the federal reasonable efforts model that everyone's been trained on, and that is you have a permanency hearing. If you're going to change the plan to adoption, then theoretically the court relieves you of reasonable efforts and you try to get that concurrent plan implemented in a pretty reasonable fashion. The problem is with this KAW case, we now have to provide information at the time of the TPR trial on how the conditions are harmful to the parent of the parents are harmful to the child, and that is your KAW case. Okay, past abuse and neglect must be updated at the time of the TPR trial and convincingly linked to the potential for harm to the child. I think what the federal statute says is even if the court relieves you of reasonable efforts, you still have the option to make reasonable efforts. And what we're seeing across the state is reasonable efforts are being made up until the time of trial. In some cases, the GAL, the social worker, may go to the house on or before the day of trial. Continued efforts towards reunification and continued visitation with the child provide you with the evidence of how, at that time of trial, the parent's actions are still harmful to the child. And in one case that I had, it was one of the last TPRs I did before I took this job, and there'd not been a meeting with the family for 4 weeks, 6 weeks prior to the time of trial. Most of the time, the attorneys that represent parents, you kind of worry about what they're going to do at the time of trial and whether they're going to put their clients on. Well, in this particular case, when I prepped the witness right before trial, there'd not been a meeting in the last 4 to 6 weeks. So the things you worry about in those kind of hearings are when you get to trial and you know nothing, you have no evidence to put on of what's going on in the last 4 to 6 weeks or so of trial, and the attorney for the parent puts the parent on the stand, and the parent testifies that yes, they have a house, yes, they have a job, yes, they're doing everything they're supposed to on their drug and alcohol plan. And they run through a list of everything they're doing that potentially might not be harmful for the child. And again, you're doing social work in an evidence-based system. So if the testimony of the parent is credible, then you've got the evidence of the parent that they're doing everything they're supposed to against the evidence of the division, which shows that we have no evidence to go against it. So when you weigh, you're going to weigh the evidence. The weight will be on what the parents said. And that's happened in a couple of TPR cases that have been lost recently in the last 2 years. We see that as a general rule, some of these TPR cases, there did not appear to be any reasonable efforts post-permanency hearing. And consequently, when they got to the time of trial, there was no evidence of meeting with the family or the interaction between the parent and the child. And there's only evidence on the other side by the parent and by whomever they bring in as to everything that they're doing that they should be doing and therefore should not be a harm to the child. So it all comes down to that evidentiary basis for providing services at the time of trial. Let's see. Timeliness is a big problem as a barrier to TPR, and it's spread across the whole spectrum. We need timely referrals to the juvenile office or to DLS so they can take a look and make sure there are grounds, get their petition filed, get their evidence put together, and then just like we do investigations and want to have our evidence hold up throughout the process, it's the same way with the TPR. You want there to be enough evidence that the trial court will find a judgment that TPR should occur and that the appellate courts will uphold it. So we need the timely referrals, and they need to be complete. We also need timely filings of the TPR petitions, which means the JO and DLS attorneys or the pre-adoptive parent's attorney need in a timely fashion to get their work done. And then under section 453.011, timely TPR hearings and appeals are required to be expedited by the court. Let's look at guardianship as a permanency plan. In guardianship, the guardian assumes legal custody of the child, but the parent's rights are not terminated. They still have a duty to support their child. They still have a duty to maintain the parent-child relationship. We talked earlier when we were talking due process that the parents have a right to due process in these guardianship cases. So the proposed guardians have to file that petition for what the parents have done wrong that will meet that legal standard required for a Chapter 475 guardianship, and that legal standard is unfit, unwilling, or unable. Again, if we have an older child, the child must consent. If they're 14 or older, they must consent in writing to the guardianship. We all know that what works really well with guardianship are relative placements, and that's because subsidy is usually available for relatives. In all the years that I was involved in cases, I can only think of maybe one or two where a guardianship was done by foster parents. And this was a child 17 turning 18 that needed to get out of care and needed this guardianship done. But usually it's with relatives because of the availability of subsidy. And when we're talking relatives, we're talking grandparents, blood aunts and uncles, first cousins, adult siblings in relationship to the child. So there used to be a concern about, well, guardianships aren't permanent. Well, no, they're not, but the court has some built-in protections for a child who's been placed in a legal guardianship. The parent may get out of prison and is fit to care for the child, but the court also has to make a finding that it's in the child's best interest. And there's some mixed results with guardianships because sometimes the families think about it and decide, is there a way we can get the state out of our case? Okay, parent, you sign guardianship to me as a grandparent. I'll do the guardianship. The jurisdiction terminates when the guardianship's done. And sometimes what do those grandparents do with the kids? They give them right back to the parents. We know that does happen. But I've also seen some very successful guardianships. There was a young mom who was sowing her oats and was wild, and her paramour severely injured the child. Well, the child ended up early on in a guardianship with a maternal grandparent. 3 or 4 years later, down the road, I happened to be back in probate court for another reason on another case, and up pops his grandpa. And he gets on the stand and he asks the court to terminate jurisdiction because his daughter's gone to school, she's got a good job, she's married to a nice man, she's capable and fit to take care of this child. And the court terminated the guardianship and returned the child to the parent. Let's look at barriers to guardianship. Again, the absent parent is an issue because we have to identify and locate parents. And if we've not identified and located them, it may stall the guardianship proceeding for quite a while the attorney for the proposed guardian is trying to find them so they can locate them for service. Remember, due process requires notice and opportunity for hearing, so they're entitled to be served. ICPC can be a barrier to guardianship. Again, if the application is not timely filed, if the placement is not timely made, and then you have to wait 6 months for finalization. So if you think that an out-of-state relative who may not be appropriate or it may not be in the child's best interest at the current time because you're working reunification with the family in your town, and the out-of-state placement would prevent that type of reunification. So maybe early on that placement isn't appropriate, but those relatives are interested, you encourage the relationship to continue, then maybe at the 4-6 month mark you're going ahead and doing the application, trying to get the placement approved, knowing that placement approval will be good for 6 months. Also, don't forget about subsidy because the subsidy has to be in place before a guardianship can be filed or can be completed. And then don't forget about our older youth. They have to be willing to consent in writing to the guardianship. So now we've talked about legal fundamentals, we've talked about court processes, and we've talked about permanency planning and barriers to adoption and guardianship as permanency plans, which of course are the two concurrent plans that we're focusing on today. So how does all of this work? Well, concurrent planning is kind of a mix of family-centered casework and legal strategies. And again, the easiest way to explain that is that you're doing social work in an evidence-based legal system. So you're doing all the good social work, much of which is becoming more and more regulated by statute. And then you know that because of all these legal constitutional rights, the state laws and federal laws and due process, that there's some legal strategies or there's some evidence that has to be proved in order, number one, to send a child home for reunification before you ever get to concurrent plans of adoption or guardianship. So let's talk a little bit about these, the following concepts that deal with concurrent planning. So concurrent planning is expedited permanency for the child, and it requires full disclosure, family engagement, front-loading services, placement stability, all the team members fulfilling their roles, and then decision makings and case plans that are legally sound and well documented. Well, maybe we start with what does all of this mean? Well, good social work practice is that which is well documented and suitable for the court. So it's all the good faith efforts you make towards reunification. And then it's put in your court reports. And suitable for the court, what are we talking about? Well, if the adjudication gives you the reasons why the child came into care and you provided services to address all those issues, then you should have well-documented evidence or reasonable efforts to return the child to the home. And where we're going to end up on concurrent planning is all the good faith efforts you provide on the front end of the case are what will get you to your concurrent plan, enough evidence for your concurrent plan when reunification is no longer the permanency plan. The judges are going to base their determinations on evidence, whether it's from the court reports, from testimony or documentation, depending upon how the information comes into them and what the statutes allow. Well, what are legal strategies? You have to keep in mind the legal requirements and limitations that affect all the decision making. If we've got a 16-year-old child who doesn't want his parents' rights terminated, then it's difficult to have a concurrent plan of adoption. Placement plays a big piece in that. To make a recommendation that a child return home, you have to have a good case plan that is legally sound and good documentation of the family's participation in the plan to support your recommendation and decisions by the court that the child goes home. Legally sound meaning we know what was court adjudicated, we know why the child came into care, we've provided services to address all of those issues that the parents have admitted to or have been part of a contested hearing in court, and we have enough evidence based on all the efforts that we have provided to this family that all those safety concerns have been alleviated and this particular child can go home. All of us know, at least from my work as an attorney over the years in juvenile court, is that if you want the judge to make your decision, you can't just stand there and stomp your foot and say, I'm right. What really works is when you have the evidence to give the judge the reason to make the decision that you think is in the best interest of the child. To implement a concurrent plan of adoption, again, we're still on legally sound case plans and decision making. To implement a concurrent plan of adoption, the worker must obtain a consent to termination of parental rights or have sufficient documentation to support at least one legal ground for TPR and best interest. To implement a concurrent plan of guardianship, the worker must have sufficient evidence to support how the parent is unfit, unwilling, or unable to perform parental duties. Okay. Good documentation includes court reports, CS1s, testimony about services and case plans. I think all the information in the files that go to the case narrative have a lot of very important information as to what efforts you're making and all the contacts you have with the families, and all the documentation on the written service agreements and all the plans and services that are offered to the family. Full disclosure is a big piece of concurrent planning. We have to tell the parents, and I think this is trained very well for all of you. We want to put this child home with you, but we need a backup plan in case the child can't go home. And you talk about how a parent has a will, where if something happens to them, what's going to happen to their where their children are going to go, and that's a very good way to explain it. Also, the 15 out of 22 months, the fact that if we hit the 15 out of 22 months that the child is in foster care, then we're looking at adoption as the permanency plan unless there's compelling reasons not to terminate parental rights. And we tell that to our families up front. But full disclosure and family engagement, they kind of go hand in hand, and they've changed a lot with the changes in the relative placement and the grandparent placement statute of 3 hours. So family engagement requires a diligent search for the family, for the parents, and to look at reasons why we can't place with a parent that's found. Federal law requires us to notify grandparents and all adult relatives, so it's not just engagement of the parents, but the family. Missouri prefers by statute, placement with relatives over non-related caregivers, and grandparents get first dibs. When we're talking with the families about placement with relatives, I think that has changed quite a bit. Confidentiality is important, but we have an affirmative duty to go out and look for the parents. We have an affirmative duty to go out and look for relatives. So that tempers our confidentiality when we're dealing with outsiders, because you have an affirmative duty to go out and look for them. Now, when you call a relative and say, we have a child in care that's a relative of yours and we'd like to know if you're interested in placement, that's a lot different than dishing all the dirt with them about the mother's mental condition and chemical dependency and other HIPAA things that you would be prohibited by law as part of confidentiality from releasing. So there's not just a clear-cut discussion with the relatives. Now, are all those relatives willing to dish with you? They'll probably tell you all kinds of stuff about the family. The other thing that's important for the parents and family to know is that the parents may have a preference for where their child is placed, and it may be with kin or other people they know that are not related. But we have to learn to talk to them about how the law requires us to place with grandparents and other relatives unless it's contrary to the best interest of the child. So we have to talk to parents differently, and then we have to talk to relatives differently. Relative, please take placement with this child. You're someone the child knows. We would rather place with you than to place with someone they don't know, like a foster parent. And sometimes, especially our grandparents, sometimes there's so much going on in the family that they're not able or not willing to take placement at that time. So what do? I think we need to give full disclosure to these relatives. Please take the child now, because if you don't take the child now and you realize there's a serious problem 9 or 12 months from now, you may be competing with another Missouri law that gives preference to the foster parents that have had this placement for 9 months. So, and I think you need to make more than one effort to work with these families, especially when they're willing, when they need changes in their home, they can't quite pass the home study. You know, we can continue to foster visits with those family members until such time as they can pass the home study and get the placement. Front-loading services. The front-loading services piece we've talked about a lot. We know why the kids came into care. We know what was adjudicated. We're providing services to alleviate those safety concerns that brought the children into care. So you provide reasonable efforts by state and federal law. They're focused on the factual basis that results in the child coming into care or any other underlying causes that came up in the CAIN investigation. And then you document well all the services that were made. Placement stability was one of the ones listed. That's that relative placement piece. Kids do better if they're placed with relatives. Again, I think this is just codified good social work. Don't forget your ICPC time frames, and that ICWA may apply. If a child has Indian relatives, then we know those tribal preferences for placement may exist. Okay. So let's talk some more on concurrent planning. There's actually a law that says, under Missouri law, the division can concurrently engage in efforts towards reunification while trying to establish another permanent plan for the child. So. I think the road to legal permanency is through concurrent planning. Those are all those good faith efforts to reunify, coupled with good documentation, will make the case for timely implementing the concurrent plan once reunification is no longer the permanency plan. And again, the best successes are when the child gets to go home. I think that's the greatest success you can have. But with all the good faith efforts that are made to return the child home, when that doesn't work, then that will give you the evidence you need to implement a concurrent plan of guardianship or of adoption. So, concurrent planning begins day one, and it really begins with placement. You're looking for relatives. You're going to document your efforts to develop a concurrent plan and articulate it. One of the circuit managers out of the one of the counties told me that they have kind of changed their way of even looking of placement with relatives to where they're going to assume that they're going to find a relative and place with a relative. And even if they place with foster parents, they're spending their time trying to rule out relatives. So their concurrent plannings are going to be guardianship or adoption with a relative, even though the child is placed in foster care. So concurrent planning from that perspective is all relative. We have to make diligent efforts to locate and place with a relative, particularly a grandparent, within 3 hours, except when it's not in the child's best interest and subject, of course, to them passing the background checks. And then we have to make the continued diligent efforts to locate, contact, and place, and continue until that placement is made. So the law mandates that preference with relatives unless the court makes a specific finding that it's contrary to the child's best interest. And anybody ever had a case where the child comes into care and you have 4 sets of grandparents that want placement? Okay, the child's grandparents on both sides were divorced and remarried. I mean, it makes for an interesting case, but you're so busy early in the case dealing with the relatives that you're liable to get to permanency much faster because of those relatives. Okay, relatives are defined by law within the 3rd degree of consanguinity or marriage. Okay, so blood or marriage. And it's important to remember that relatives are a subset of kinship, and what these laws on relative placements make us look at is that the people that live close to the child or from church that have a relationship with the child may not be the first placement because of the law that requires us to place with relatives first. Again, if you're having trouble locating relatives, there's, just like with absent parents, ask the court to talk to the parents about who their relatives are, where they are. And don't forget that when these kids are coming into care on an emergency basis, the landscape of children protective custody has changed quite a bit in the last 5 or 6 years. So the number of children coming into care has gone way down. You know, this year may be an exception, but has been continuing to decline until this last year. And although the number of kids coming into care has declined, what's gone up are the number of FCS cases and IAS cases. And in FCS cases, if we're doing genograms, there should be a lot of information on the files related to relatives that hopefully will give us information should the child need a placement or be coming into care. That would also be of help to us on that issue. But if not, ask the courts to put the parent on the stand and tell them who the relatives are. Under the federal law, the division is required to notify all grandparents and other adult relatives within 30 days of a child coming into care. So again, that affirmative duty to notify is out there, as well as the affirmative duty to place. Okay. So when you talk about concurrent planning viewed through this relative lens, then if a child is placed with a relative, the concurrent plans become adoption by a relative, guardianship by a relative, And if you have someone who's not willing to do adoption or guardianship, but maybe they'll keep the foster care placement as a relative. And we don't want to forget, and we want to appreciate our foster parents. Nothing prevents placement with a foster parent when there's no appropriate relative for placement or when it's contrary to the best interest of the child. So how do we implement the concurrent plan in a timely manner? Well, it's all those good efforts up front, reasonable efforts towards reunification, identify and locate parents, efforts made and documented throughout the life of the case to develop and then to implement the concurrent plan. So in conclusion, when you start with the premises that we're providing reasonable efforts and the child will go home, and despite all the reasonable efforts that you've made in good faith to put that child home, it's not safe for the child to go home, then all of those efforts, which are well documented, will provide you with the evidence you need to implement a concurrent plan of adoption or guardianship.